Court of Appeals, Division 1, is now in session.
Morning. Please be seated. This is the time set for argument in Pan Am versus Goal. Our cause number is 1CA CV140753. Counsel, as I'm sure you're aware, we have read the briefs. We've conferenced the case this morning. We're well aware of the facts and issues, so please bear that in mind as you begin your presentation. We're being audio and video recorded today for dissemination on YouTube, so please announce your own name and that of the party you represent when you approach the podium. Each side has 20 minutes for oral argument, and the appellant may reserve as much time as you wish, subject to watching your own clock. And with that, we can begin.
Thank you, Your Honor. May it please the Court. We're here today on an appeal of a landlord-tenant action arising from a rental of apartment from New York. I'm not going to go through the entire history of the case, but I will briefly outline some of the issues. First of all, I think it should be noted that this is a de novo appeal. It's from a summary judgment. There was no foreign judgment action filed in this case pursuant to the Uniform Enforcement of Foreign Judgments Act. It is simply a ruling on a motion for summary judgment. The appellant believes that this summary judgment must be reversed. This is basically a simple case. What happened in New York was the appellees leased an apartment. They termed early, and when they terminated early, they were in breach of the lease. The landlord at that time filed an action for possession in New York court, and
Well, it filed an action for more than possession.
It did request more than possession. Mm-hmm. And the fact is, when you're dealing in New York, you don't know if you're going to personally serve or not. And the fact is, yes, it did request certainly more than possession. However, it went to the court, and the court granted possession to the landlord. Now, the issue that the trial judge and appellee's counsel got hung up on was, hey, look, this is somehow they've ruled they gave you nothing for damages. Obviously, the judge considered your claim, and she decided that it was not appropriate. Here it is, a default judgment situation. The only evidence presented was the evidence of a breach of a lease and the evidence of 2 months unpaid rent. However, if you take a look at the form judgment that was submitted, that was signed by the court, it says something else. And I just kind of noticed this yesterday for the first time when I was reviewing this. And it states, and I quote, it said, respondent's failure to file an answer as follows. Judgment of possession is granted in favor of New York Plaza Residential LLC and against Goel, Paresh, Nagin, Ushake. A counterclaim is granted in favor of the respondent in the amount of $0, parentheses, which if not being entered separately is offset and reflected in the total amount due listed below. There was no counterclaim filed in this case. This is a form document. This was a claim for possession and for nothing else.
Well, the language as you read it, you say you noticed it for the first time yesterday, and so I'm only listening to you read it orally, but it didn't seem to make sense to me anyway. Right? The counterclaim, the judgment is granted against the respondent on the counterclaim. Wouldn't the respondent be the counterclaimant?
One would think that.
So the fact that the form is inarticulately drafted, I don't know if that gets to the issues of jurisdiction that underlie your argument.
I believe it does, and it does because the court. First of all, the one person who was involved in this case signed an affidavit that was Todd Nahans, and admittedly biased, but he was the attorney for the plaintiff in the New York action. And he was the one who stated very clearly that this was a claim for possession and for nothing else, and that this is how things are done in New York. Now, counsel has pointed out that it's permissive to do it otherwise. However, that's not how things were done in New York.
But counsel, can I ask you a question? If the form that the court signed was either in error or confusing, wasn't it incumbent on your client to file a proposed amended judgment or to appeal from that judgment?
I don't believe it was, because it is a form judgment. It is the way. Unfortunately, sometimes things become automatic. I know sometimes I sign documents which are automatic, and sometimes some courts, when they have a huge volume of landlord-tenant actions, might sign something automatically and have a particular form that is there.
But then your client has to react to the result of the case it brought, right? It brings a case for possession and damages. It serves as it serves, and I suspect that if the damages amount had been filled out in the amount of $100,000, you probably wouldn't be here, right? You probably would have tried to collect that judgment and not say that there was no jurisdiction over it or there was improper service or anything like that. So to the extent that once you get the judgment, your client looks at it, reflects on it, isn't it incumbent on your client to take action to deal with any dissatisfaction it has?
Not if the method of obtaining judgments in New York was to get possession and that they had not even gone in to inspect the premises yet. How can a trial judge here rule on 5 months down the road, 5 more months of rent were due? That wasn't in the complaint, was it? It was nowhere to be found.
But the trial judge ruled on the damages request that was made in the complaint.
Okay, that's fine. But this trial court, we filed a claim in Superior Court in Maricopa County for 7 months of past due rent, not 2 months. That claim was not ripe. The landlord had not yet gained possession to even inspect the premises for damages. And to suggest that somehow, well, gee, you didn't get anything for the first 2 months, we're not going to give you anything else for the other 5 months or for any damages that might have taken place is somewhat ludicrous. To think that a court can reach that far out to make that kind of determination when it was never even presented in New York.
What was the exact language in the complaint concerning damages?
In which complaint?
The New York complaint.
Actually, I'm going to have my certificate. Because I don't believe it asked for the damages that were subsequent to the rent that was actually incurred.
We're looking at DEF 057, which is just the last page of the complaint.
Okay.
That contains sort of an all-encompassing but ambiguous demand for rent.
Right. But
I suspect that if you could find DEF 0056 or 55, we might find the answer.
You have that? We're looking for that. I would suggest that
In the meantime,
no matter what was requested of that complaint, the court could not have granted for an additional 5 months because the court didn't know what those damages were, and how can you present a judgment on facts that have not even before the court have not even become ripe yet? I'm sorry. Thank you. So this shows the total due of $58.88.36. Is that what you're looking at? And it said the rent has been demanded. They haven't paid for it. They're in default.
we don't have that page handy on the bench.
Are you reading from 58?
I'm looking at the page before. It's a 3-page complaint. Do you have the 3 pages?
Not in front of us. We have 57. We do have 57 and 58.
We need 55 and 56.
So, Mr. Hammerman, you're suggesting that your client could have filed serial causes of action, having asked for not only possession but back rent in the first action,
Yes.
and then waited, and then filed another action?
Well, Your Honor, the procedure in Arizona is somewhat similar, and that is that one files a forcible entry and detainer action in Arizona to obtain possession. In Arizona, they will grant you the past due rent. However, once that possession is granted through the forcible entry and detainer, the landlord then goes into the premises and assesses what damages have taken place, determines if there's further rent that may be due, and if that is the case, they file a separate action for that.
But in Arizona, we have a nice clear statute that says the
We
FED is
do.
for possession.
We do.
And New York is a little less clear.
Well, they would not agree with Your Honor on that, I don't think. But but I think you're correct about that. However, to me, to suggest that this action filed in Maricopa County, that the action filed originally in New York also litigated what the landlord ascertained after entering the premises, it makes no sense, because that cause of action was not ripe. It wasn't ready to go. No one knew what those damages would be. As we all know the cases of landlords who go into premises and find a lot of damage, missing things take place. The damages are assessed after entry is gained.
Yeah, but that's a little bit different than the rent that was sought, right? I mean, my understanding, and correct me if I'm wrong, is that your client sought the entire amount of rent. It's sort of like an acceleration clause, sought the entire amount of rent owing till the end of the lease term.
No, that's not what it says. Absolutely not.
Did you find the part of the complaint that identifies what it sought?
Yes, if we look at it says, and I'll read section 4 of the complaint. It says the premises from which removal was sought were rented for dwelling purposes and are described as follows: all rooms at apartment 10G, quote, the demise premises in the building known as 2 Water Street, situated within the territorial jurisdiction of the Civil Court of New York, County of New York. Pursuant to said agreement, there was due from respondent tenant the sum of $5885.36. It breaks it down: April 2011, March 2011, and legal fees total $5888.36.
No other demand for rent until the end of the lease term.
I'm reading, said rent has been demanded from the tenant by notice in writing, same due became thereon. A copy of said notice with proofs of service is attached here too, and the terms of said notice are incorporated by reference.
Don't you love the way they draft pleadings in New York?
Pardon me?
I said, don't you love the way they draft pleadings in New York?
They do it beautifully, yes. Yeah.
Almost incomprehensible, but go ahead.
It is. I did say, though, legal fees $173.36, so not everything is more expensive in New York.
That's comforting to know.
So
I'm saying that
guess
the part of the case has not been litigated.
So my question is why didn't your client file the subsequent action in New York?
Because they could not find the defendant. That when the defendants were located in Arizona, they chose the forum of Arizona to serve the defendants in an action out here. That's a forum choice. As someone who does a lot of creditors' work, frankly, we receive a lot of cases from other states where the debtors have relocated here, and we pursue our legal rights here because, frankly, if we're going to collect, it's going to take place here. Okay. I'd like to reserve the last minutes, if I may.
Certainly.
Good morning, judges. Jacob Kubert on behalf of Appalese, Parrish, Goel, and Ushanegan. Your Honors, this case is a classic attempt to take a second bite out of the apple out of a new jurisdiction that's 3,000 miles away.
But was there an attempt to take the first bite with regard to prospective rent?
I believe so, Judge.
Where is that?
I'm sorry? I missed that.
Where is that in the record?
That they tried, I'm sorry, that they tried to.
The real question here in my mind is whether the New York action fairly included the entirety of the claim asserted in the Arizona action. And if the only claim in the New York action was for back rent, that would seem injurious to your claim preclusion argument. If, on the other hand, you can show that the record contains a request in New York for rent till the end of the lease term, that would be helpful.
Judge, I'll, in the interest of full candor, I don't believe that the complaint asks for full rent through the lease term. However, I don't think that that injures our position because I believe that the first 2 months that were denied is a important predicate to be awarded in order to pursue the next 5 months of unpaid rent. This is the first 2 months are a predicate. I don't understand how they could be denied yet.
Well, it certainly sets a tone, I'd agree, but one of the elements of claim preclusion is that you have to, the second claim, if it's to be precluded, has to be a claim that was or could have been litigated in the first claim, right?
Correct.
And here, if we have a claim that not only wasn't litigated in the first claim, but couldn't have been litigated in the first claim because issues of mitigation and et cetera were not even ascertainable at that point, how can claim preclusion apply?
Again, I think it's looking at it from the other angle. It's that the first 2 months need to be awarded in order to pursue the next 5 months. I'm not understanding how.
I mean, it would certainly be nice for logical consistency, but where's the law that says that you've got to get the first 2 months to get the next several months?
I did not look for that area of the law. However, in attempting to untangle the morass of New York law to lay out the defense here, there was significant law that we found that the First Department, the landlord-tenant judge in New York, who's intimately familiar with landlord-tenant law and the issues there was binding precedent that landlords are under an obligation to mitigate their damages in New York residential leases.
But what if they're unsuccessful?
Unsuccessful in mitigating?
Yeah. I mean, indulge the legal fiction that an apartment in New York just can't be rented for 6 months. If the landlord is unable to mitigate, isn't the landlord then entitled to full damages?
Perhaps, but in this case, there was no mention in the complaint that the landlord pled that it did, in fact, what you're suggesting, attempted to mitigate. And the record that's before this court, the only record that we have, is that indeed the landlord ignored the tenant's the tenant's efforts to mitigate. There's emails in the record that the tenants vetted subtenants, provided the notice.
Sure, but that goes to breach of the lease. That doesn't really go to the issues we're concerned with today. I mean, the issues I'm talking about are the landlord's duty to mitigate. Let's assume the tenant just vacated, didn't pay rent, and the tenant is liable on the lease. The landlord still has a duty to mitigate going forward, but at the time the landlord sues for possession, there's no way to know if those mitigation efforts are going to happen, if they're going to be successful, or if they're going to be partially successful, what the landlord's rights truly are until the end of the lease term. So how could it have sued for the damages that are issued in the Arizona action at the time it sued for possession?
If the New York law and Arizona law are similar in the respect that the claim doesn't ripen until the rent becomes due, then to answer your question, I don't believe that the landlord could have made that claim in New York.
So if it couldn't have made that claim in New York, how are we to find it precluded in Arizona?
I mean, I'm going to sound repetitive, but I still believe that it's those first 2 months that the claim was before the judge on those first 2 months. And I think it's fatal to the landlord's case that the judge denied those damages for those 2 months of rent. For whatever reason she did it on, we don't have a record. That's the landlord's failure in New York to procure a record for this court to review to see what exactly happened back there. All we know is what's in the record. And what's in the record is they made a claim for unpaid rent.
For 2 months.
For 2 months, correct. They made a claim for 2 months of unpaid rent. They did not withdraw that claim. They served.
But those 2 months at the time were back rent, right?
April and May.
I think it would be very telling if they were prospective.
They were half of March, they were for half of March 2011 and April 2011.
And the complaint was filed.
And the complaint wasn't filed until mid-May 2011 for whatever reason.
So it was back rent.
Yes, it was back rent. But what I was saying was the claim was filed, claim wasn't withdrawn. The petition for unpaid rent and possession were both served. After the affidavit of service and the landlord's counsel, who's the experienced New York lawyer, saw this affidavit of service that was by conspicuous service. Did they withdraw the unpaid rent at that point? No. This is the attorney that supposedly knew that service could not give him unpaid rent at that point. So, but what did he do? He filed They aggressively pursued the unpaid rent. They filed the affidavit for final judgment. Now that's in the record. They're asking for final judgment. Whether it's on 2 months or 7 months, I can't recall. But in that affidavit, he did request a final judgment for unpaid rent after knowing that service was, do I have it or not? So they pursued it after that. They spoke to the tenant.
So you're coming down, in essence, saying that after the Landlords Council in New York saw the type of service that was done, they filed an affidavit for final judgment. And to the extent that final judgment may have asked for all months' rent, not just the back
I
rent.
don't know that, Your Honor.
I understand that. I
Okay.
didn't say, but what if it asked for only the back rent of 2 months? What does that do for you?
I'm not sure what it does for us. All I could say is that it wasn't awarded. Why? We don't know.
But again, it was a default judgment.
It was a default judgment,
Right.
and
Do they have an
they controlled the
obligation- Do they, normally, mitigation of damages, they have a duty to show that, in the normal course, like in Arizona, you're saying the landlord would have a duty to come forward and say, I mitigated damages. And so you're saying it's possible that in the New York court, they didn't show any mitigation of damages, and therefore that may be a reason why the judge said no back rent?
That is correct, Judge. We don't have a record of what this judge in New York relied on. That's not our fault. We weren't there, obviously. We were in default.
But how could she have ruled, I think it was she, but how could the judge have ruled on failure to mitigate on future rent? Assuming again, the affidavit only said, we want these 2 months. And assuming, for purposes of argument, that the court was concerned about failure to show any mitigation of damages for those 2 months, how could the landlord have shown failure to mitigate of damages for the future rent?
What I would say about that is, Judge, is that the first 2 months, now, I don't know when the high time for renting is in New York.
It's always high time for
It
rent in New
is,
York.
which is why they should have put somebody in there to save our tenants. It's a mobile society there. But our clients, they vetted subtenants. They conducted the credit checks. Now we're entertaining hypotheticals and I'm trying to follow it. But if that was pled and that was known to the New York judge, and if those subtenants were put in that unit, that could have carried out for the entire balance of the term. So that would have given they would have had no reason to entertain, well, when could they have mitigated?
You've got the complaint, right, and you've got the affidavit for final judgment, and there's no evidence in those of any mitigation of damages.
Correct.
So the judge couldn't have relied on, I'm going to deny future rent for failure to mitigate, because she wouldn't have known about what happened with the proposed subtenants.
That's correct. And the lack of the record hurts us in that regard. And now we're here years later. This is a 2010, excuse me, this is a 2010 lease. It's a 2011 complaint. It wasn't brought back out here to Arizona for a year later.
Sure.
They made, the landlord made arguments in their summary judgment that there's an issue of fact as to what the New York judge entertained in reaching her judgment for unpaid rent, which was a 0. We don't have a record of any of that.
Yeah, do we care? I mean, does it matter what the New York judge entertained? Isn't the question just whether the claim is precluded? And on the doctrine of claim preclusion, we don't ask the reasoning for the resolution of the underlying claim.
That's true for the doctrine of claim preclusion. Going through this, it seemed like it was a two-part inquiry. It's whether the judgment on its face should be given full faith and credit, and whether res judicata or claim preclusion applies. I think under the full faith and credit analysis, it's pretty straightforward. Was jurisdiction acquired, and was due process satisfied? I don't think there's any dispute that occurred. There was jurisdiction in New York court. They served the tenants.
Right.
Okay,
So
so
you'd agree
we-
that full faith and credit,
Full faith and credit on the face of the document.
anything worded as in such Elizabethan terms deserves some sort of credit. So let's assume that it gets to full faith and credit. Then the question is whether the elements of claim preclusion are met. And I come back to the question of whether the claim at issue here actually was or could have been litigated. So, and let me ask you the direct question then. It seems that the back rent was litigated, and the award was zero. That claim is precluded. But to the extent that the remaining rent couldn't have been litigated, why isn't that fair game for litigation in a subsequent action?
Because those 2 months, if mitigation occurred, would have rendered the next 5 months academic, so to say. We don't know if
That's
somebody could have been put in that apartment.
That's a defense on the merits. That's not a defense to the doctrine of, or the inapplicability of claim preclusion. I mean, that's an argument that if summary judgment hadn't been granted, you can go forward and say, you should have allowed us to mitigate, none of this ever would have happened, and the judge might agree with you.
You're correct. It is a question of on the merits, which in and of itself involves some review of the record of what happened. I would have to imagine that the record is very significant on what was considered. In order for us to defend the claim, what was considered? What did the judge do there? Are we second guessing what she was thinking about mitigating, about when the landlord could have gotten tenants in there, about the landlord's prospective mitigation?
But they never litigated the future rent. I mean, there's no evidence, there's nothing that shows that that was a claim.
And if the case in Arizona had gone forward, those would be powerful arguments that you could make on your client's behalf. But we never got to the question of considering such facts.
That's all true. It's not in the record, and I'm not trying to be evasive. I think the only way to really consider it is just from a logical perspective of how the first 2 months could be denied, and then the next 5 months could be awarded, all things considered. That's really what the argument boils down to. It's a logical type of analysis. So you didn't mitigate the first 2 months, so we're not going to give you unpaid rent. But you didn't have a chance to mitigate thereafter, and it hasn't been in the record, so we're going to give you this rent for these other periods of time.
Not necessarily.
Or we're going to
Getting
wait
rent.
and see.
We're going to wait and see, right. You're going to litigate that when the new claim is brought. Because they only have to bring a claim, as I understand it, they bring a claim, in essence, for forcible entry into tenure, for possession of the premises, and ask for back rent. And then can come forward and ask for the remaining rent in a later separate action. Regardless of what the court's reasoning was as denying the first 2 months, the second 5 months were never litigated.
I
Weren't
can't
even
dispute
claimed.
that. Those 5 months were not litigated. That's
They weren't
correct.
even claimed. They
Not
weren't
even
even
claimed.
claimed.
That is correct.
So it's hard to say res judicata when that's the case.
I understand that. But again, it just comes back to those first 2 months. There was your chance to mitigate. You didn't mitigate. You had tenants right there waiting for you that were vetted, and it was totally ignored. Cut off, no communication, email responses, nothing. And if those tenants would have been put in, and again, we're all it's hypothetical, then we wouldn't have the rest of the claim out there. Is there any other questions I can answer?
I don't think so. Thank you very much.
Just a couple of things. I do agree with counsel that it is a question on the merits. I agree with them that the other 5 months have not been litigated. As to the issue of mitigation, which I think is a non-issue, the case law in New York, namely White House Estates versus Post 173 Miscellaneous 2nd 558, says that a landlord on a residential lease has no duty to mitigate where the tenant has abandoned the premises prior to the lease end.
Really, that's not an issue before.
I don't believe that's an issue that we get to. I think we do need to discuss and I don't want to keep beating this one, and that is the form judgment which the judge signed in New York, where it says a counterclaim is granted in favor of the respondent in the amount of $0. The respondent is listed as the tenant. How can that be? There was no counterclaim filed. The defendant never even appeared. This is clearly an action for possession that we don't really have to guess on that.
What did the affidavit for final judgment say? Do you have the record reference, by the way, of that?
We have the final judgment,
No, but there's an affidavit apparently for final judgment.
the one filed by Mr. Nahans at the summary judgment, or?
No, I'm talking about in the New York court. If somebody had to ask for when there's a default, right, the tenant's defaulted, and my understanding is, to get that final judgment, the one you were just reading from, that the landlord had to ask for a final judgment and file something for it. Do you have the record reference on that?
I have whatever the record discloses. I don't know that there was a separate
We'll find it.
submission.
Okay.
Then let me ask you a different question. In the language you just read from the form judgment, is there a blank by which the courts could say that a counterclaim is denied, or is it
No,
just...
actually, the counterclaim was granted.
Right, but that's the only choice for the court is granted. And so if the court wants to say denied, it says granted in the amount of $0 under that
I
form.
suppose, but
This is not the first time that I've been a little picky about the language they're using in New York, but this is one of the reasons to care about the issue, because it seems like the form only allows the judge to deny or even deny the existence of a counterclaim by writing in zero. And I agree that's horribly inelegant, but you can sort of understand if that's the court's form, why the judge would write zero if there is no counterclaim.
right, and the same type of zero is also printed in as far as the plaintiff's damages, because it was a possession action, as Mr. Nahans has signed the affidavit to that effect.
Leaving us...
But it wasn't just an action for
It
possession.
was an action seek. I agree, Your Honor. He was
damages.
seeking back rent. However, and this is practice in New York, so I haven't told you it's not practice here, and that is that you do not seek money damages. You are not awarded money damages unless you can personally serve someone.
Well,
And the service,
on the case law I looked at, there's a tremendous split.
It's
in
permissive.
New York courts. There's a great percentage of them that allow landlords to collect back rent when they have substituted or alternative service.
I agree. I agree that that's what the law says, but it's a question of how the law is also sometimes enforced. And it is permissive. It is not mandatory. It's not
So are
compulsory.
you saying that even if there is conspicuous service, the trial court has discretion to grant back rent if requested?
It depends upon the practice of that particular division, that particular court.
That 1929 case that said you can't.
Sometimes we have to rely on those. Yes.
And I guess the real question is that we will never be able to figure out is, did the court enter zero for your client's damages because it perceived a failure of proof, or did it enter zero because it felt I'm not going to exercise that permissive jurisdiction?
I think that the court ruled based upon what states of the New York practice, and that is, I'll grant you possession now. After all, your conspicuous service was by a nail and mail.
But it doesn't say that.
I
So I'm
agree.
saying
We're stuck with what it says.
Right.
There's no doubt about that. But there's also no doubt that the remaining 5 months of past due rent have not been ruled upon, and counsel has conceded that fact today. And we pray that the judgment be reversed. Any further questions? Or yes.
I'm still concerned about your point about permissive awarding of rent. Even if they don't have, I want to make sure I understand your position. I thought your position from the brief was the trial court couldn't have granted rent under the 1929 case.
I believe that there has been subsequent cases which permit it. I'm not going to deny what the law says, certainly.
I understand that. But are you saying that the trial court, knowing that it was in that department from the 1929 case, was basically saying, I just can't do this? We're exercising its discretion not to do that.
I think the court is stating that it is our practice in New York to not grant a money judgment unless there is personal service. That's what I believe happened. I can't speculate any further, any more than anyone else can guess. But certainly there are issues of fact that need to be litigated here at the trial court level in Maricopa County.
Should we construe the New York record in the light and most favorable to support summary judgment?
Well, I'm sorry.
Should we construe the trial court record in New York in the light most favorable to affirm summary judgment here?
I think you have to construe the record of Maricopa County more so than New York, because needless to say, this judgment document lacks perhaps the clarity that we would like to see. Okay. Okay. Thank you, Your Honor. Thank you.
Thank you, counsel, for your arguments. Matter is now under advisement. We will issue a written decision in due course, and we stand adjourned.
Thank you.